case of 3 former senior South African Revenue Service officials involved in an alleged rogue unit has been postponed to the 17th of February next year. This comes after the National Director of Public Prosecutions, Shamila Batohi, needed to consider a review in citing that there is no reasonable prospect of a successful prosecution. The case was being heard at the Gauteng High Court in Pretoria today. Johan van Lochenberg, Ivan Pillay and Andries Janse van Rensburg are accused of involvement in the so-called SARS rogue unit. The men were charged with offences relating to the bugging of the Scorpions and the National Prosecuting Authority officers back in 2007. The bugging equipment was allegedly installed at the NPA head offices in Silverton, and that's in Pretoria. The men have also been charged with contravening the Regulation of Interception of Communications Act and corruption. Well, let's stay with the story now as we cross live to our reporter, Pelani Pachade, who joins us from Pretoria this morning. A very good morning to you once again, Pelani. I mean, the court case then being postponed. This is something that we discussed earlier on. We saw the reports coming out yesterday that something of this nature would be brought forward by the NPA. Give us a brief background and tell us what took place in court this morning.
Well, 5 minutes, it's all it took. Judge Barrett Bam just came through and as well took the representations from both parties, of which they agreed that 17 February 2020 should be the next date of which they convene once again to whether to understand whether the charges against the 3 have been dropped. And as well, just to give us a bit of a background, I'm joined by the lawyer for the 3 accused here, and that is Bernard Hodge. Thank you very much for joining us here. What does it mean for 3 months around that there is now a postponement? What does this mean? Does it mean that your case is being heard as much as you wanted, or 4,000 pages are going to be read by the NDPP and make an informed decision on them?
Well, the law provides that my clients have an opportunity to call upon the NDPP to reconsider the decision taken to prosecute them. This is precisely what they've done. They've submitted further written representations to the NDPP, which are substantive representations, voluminous representations, and the point being is to explain to the NDPP what this case is all about, where the weaknesses in the case lie, and why hopefully the NDPP will agree that my clients should never have been prosecuted right at the outset.
Well, the voluminous papers there would perhaps be looking to better in ensuring that you point out that your clients have no wrongdoing whatsoever. But I also understand that the NPA have not submitted some documentations. Take us through that.
Well, as you may recall, my clients had to go to court to compel the NPA to disclose the full docket. The docket consists of an A section, a B section, and a C section. And the court, in fact, agreed that the entire docket should be disclosed to my clients.
And that's not been the case?
That's not been the case. They've disclosed items, and we've pointed out where there are missing items. We've pointed out where there are troublesome issues in relation to the docket. And it's not appropriate for me to go into this on the media. Suffice it to state that we have pointed out to the NPA that we believe their docket is a problem. So we're waiting for the balance of the documentation that we say should be in the docket. We've also listed further documentation that should exist, that should be in their possession, that they haven't given to us. And we've also requested further particulars which we would require them to give to us. The NPA's attitude is that whilst they've received our requests, their attitude is that they want to deal with the review of the decision to prosecute first, whereafter, if the decision is to continue with the prosecution, they would then want to deal with these issues. We obviously in a state of limbo. We've said we should never have been prosecuted at the outset. Here are our representations, but in order not to prejudice our fair trial rights any further, please give us the missing documentation, please give us the missing particulars.
In a soundbite, how confident are you with the voluminous papers that you've submitted that, of course, they'll get your clients off the hook?
I believe, as a lawyer, that anybody who reads those representations hopefully will agree that this case should never have been prosecuted at the outset.
That's Bernard Hotz there saying that the papers, 4,000 papers that he says he has submitted to the NPA for the consideration of the National Director for Public Prosecution for the next 3 months or so, and saying that he believes once the National Director of Public Prosecutions, Shamila Batohi, has read them, then she may come to a conclusion that there should never have been, in the first place, a prosecution, and that there are no prospects whatsoever of a successful prosecution should the case continue.